Hey guys, can you just give me a little, whoever few of you are in here at the moment, can you just do a little, let me know you can hear me? Just want to make sure everything's working okay. I see AF Vet here bright and early. That's very nice with some follow-up questions. I know I actually saw them on a post, AF Vet, and I did do a quick response there, but we could go into a little bit more if you're here at the moment. Rachel Casey, I see you. Nice of you to be here timely. Michelle M, nice to see you. Maeve, good to see you always. Ulysses Lewis. What if you're related to me? I'm married to a Lewis. Christina, good to see you. Okay. We're going slow at the gate here, guys. I know it's not my normal time or day. Oh, normal time, not normal day. But as most of you know, I was out of town and checking between hospital and hotel. So it just didn't seem like I was going to get back in time for the Wednesday at 1 p.m. due to discharge and all that. Hi, Dimple. Hey, AFF, I see you're back in. Okay, so let's go to it. Real quick, let me just go over some videos that are coming up. I'm just going to give you the headers that are planned for next week. We're going to have test number 2 of that 800 number, and you'll see that test number 2 did not work out as well as test number 1, which I think already published, which was super fast and super awesome. Test number 2 was same day, later time, and it was the usual train wreck. So I think it's the averaging of those. Probably most are pretty good, but you get in these 2-hour waits. I think I saw someone recently say 3 hours, and that really ruins the average and brings it up to 13 when it should really be like 1 minute. Okay, we also have a discussion on the Social Security ruling about obesity and equaling a listing, which there is no listing anymore, but you can potentially equal it, and also discussion of severity and RFCs that are affected by obesity. So it's a really important area, even though they took it out of listings a long time ago. It is super important. So we're going to go over that ruling for the details of what can be helpful to anyone who considers themselves or is clinically obese, which is many of us, right? It's not all that uncommon. We also have something about bankruptcy and the merits of bankruptcy when you are out of work due to disability. And I think my bird is in that one, maybe on the attachment. Anyway, yeah, it's something that people might want to consider amongst their other options if they have a lot of debt that they're never going to get out of, and they're disabled and not able to work and change that perspective. Of course, we have Friday Fraud Law Review coming up. This is going to be a Missouri woman who stole her prisoner brother's benefits for almost a decade. Yeah, that fraud never happens, right? Then comes out one. This was about fibromyalgia, which I know we've been discussing a lot lately because it's a little underappreciated and not treated well. And this is about, amongst other things, just the missing specialist problem. Like seems like providers are very fibromyalgia illiterate, or they just don't believe it so, perhaps. And then just one last one. This was about the work history report and the work task of stooping. That is, I would say 95% of the time, if not more, forgotten by people filling out their work histories. So it's really important, and it has SSA significance. So you want to pay attention to that if you're heading into a claim or going to be doing a work history report, or even if you're getting the idea that maybe you should redo your work history report because maybe you realize that you might have made some errors, didn't think about a lot of the things in that past job that would have been important to show to prove that you couldn't do it now. So anyway, just another one of those. We have a playlist on work history. Okay, so let's get to your questions. Thank you for your patience, guys, and I hope you all had a great week. My week went fine. My husband's doing great. He's in another room, so I don't really want to disturb him, but he's doing good. Okay, so AF Vet, and I don't know if you saw if I briefly jumped in on your post on the regular board, but it looks like we got some more details here. So AF Vet had his hearing, looks like yesterday, and the last hypothetical the judge asked to the vocational expert was if there was any job in the national economy for an individual who will be off task 10% of the time. That is not an unusual question. Judges ask it, or if they don't, usually the attorney rep or non-attorney rep will ask it. He goes on, AF Vet goes on to say the vocational expert said no jobs, which would be typical because off task, depending on the VE, it could be 10% up to 20%. Some think you can get away with more off task than others. I see 15% being probably the average. That anything more than 15%, under 15%, you're good. You can screw up a little bit, but more than 15% would be a deal breaker for an employer. So anyway, this particular VE said no jobs, says AF Vet, and AF Vet's attorney followed up by asking if that was including call off or leave early 10% of the time. And the vocational expert, I guess, repeated that there would be no jobs if that was the case. Now it's funny, let's talk about off task, which is at 10%. versus related, but not exactly the same, but I think the same result in the end is absenteeism, which can be tardiness. You're absent for the first few hours. Do you guys hear those birds and the dog? Yeah. Leaving early is, I guess, can be a part of absenteeism or can be a part of off task because you're not there, but you're actually absent. So you're not even in attendance. Same would be if you had to leave early, unexpectedly early. You didn't have a scheduled time off to take part of a sick day or anything like that, which is usually the case when we have unpredictable symptoms that can crop up and make us go home. Maybe you have a migraine coming on or it could be a GI problem. It could be one of any kind of impairment we might have that interferes with our work. So continuing on. And absenteeism, by the way, is often a separate question we ask. And most VEs nowadays are saying no more than 1 day a month. And that's kind of over a period of time. Because if you say to them, oh, are you saying they'll give you 12 days off a year? Because it's 1 day a month, but not more than 1 day a month. And then they'll say, well, no, probably at 6 months, if you're doing 1 day a month, the employer is going to be like, you got to go. But everything depends on the vocational expert, and they're all slightly different oftentimes. So you kind of have to bounce to the scenario you're in when you're in the particular cross-examination situation. What did he say? You can't just give a rote question. You have to pay attention to what he said and how the judge asked the question, because then you could actually ask a different question related, but with a different detail. Going on, AF Vet says, I have in the evidence that I tried intermittent leave and ended up calling off 2 to 3 days a week and went on full leave after that. I think that's great evidence, AF. I think it shows that you had a definite not showing up for work situation, and that you succeeded in receiving, it sounds like, intermittent leave, whether or not it was successful or not. Once you got it, which usually you have to have doctors support that in order for, I'm getting a weird notification here. Continuity camera notification. What is continuity camera? No idea. Okay. So that proof of that FMLA, intermittent leave, that could be helpful if you have the documentation. I would make sure it's in. Sometimes if you don't have that, guys, and a lot of people don't get that, if you can get your payroll information. A lot of companies now, you can get it online. Not forever after you stop working there, though. So you got to kind of do this closer in time. And it will show what days you called out sick, not which days of the month necessarily, depending on how your payroll puts it up there. And the reason why they have it up there is because they no longer give you pay stubs. It's direct deposit. So that's where I think because employees are entitled to have their pay stubs is why it is available online. So they don't have to print it out and give it to you every Friday. That will show how many sick days you took in that pay period if they plugged it in right. Vacation days, sick days, regular hours you work. And that can be helpful proof also of you having a problem with attendance. All the sick days are used and you're still taking up all these. So you're working far less than what a full-time job would allow. And it might have led to the termination or maybe a decision to quit because you just knew the writing was on the wall. Or maybe you just felt like you weren't doing if you liked your employer, you feel like you were doing them an injustice. And people leave on that account too before they end up getting terminated, which is uncomfortable, right? Okay, so AF continues. I have had medical records of a minimum 4 doctor or PT visits a month, and that I would require a 2-hour break each day. I'm hoping this is a good sign from the judge. I think I mentioned before that the judge is asking of the off-task time as the 4th vocational hypothetical is not really that major of a deal. Judges ask it all the time, and then they don't choose that particular hypothetical, and they choose one of the 3 above that they first came up with. Sometimes they throw it in just to show that they're being diligent, so that, but if the person has an attorney, unless the attorney really doesn't know what they're doing or is super new and doesn't know what they're doing, they're going to ask the off-task time. I want to say I don't know if there's any cases that it wouldn't apply to. There probably is, but I've never had one in 20 years. So I don't know that his question is all that important, okay? Because, that doesn't mean he's picking number 4. I had a judge who asked 7 hypotheticals, and then he denied the guy. We got it overturned at appeals council, actually, but on an age category change that the judge didn't take into account, not something else. 4 doctor appointments a month, that's good. You say 4 doctor/PT. PT is usually like a couple times a week, right? So I don't know why that would be only part of 4 in a month. I don't know. You would know better. Maybe you're not doing full-blown PT. Just curious there on that question there, AF. Okay, moving on. We have Rachel Casey. I don't know that we met Rachel, but it's nice to meet you. So thanks for being here. Rachel says, if I get SSI, will I lose Medicaid and when? Big Beautiful Bill goes into effect. No, the Big Beautiful Bill had nothing to do with people eligible for Medicaid and SSI. For some states, winning SSI is an automatic attachment to Medicaid. That's what the state decided. Some states don't do that. They say, no, it doesn't matter about your SSI. We have to make a determination ourselves. Some states say, we won't make a determination ourselves. You have to have SSI or nothing, which I find really strange. I think they do have a loophole where, because what if you're not eligible for SSI? Because you have, well, it's probably a financial thing, and then you're not eligible for their welfare Medicaid anyway, because it's welfare for the poor. So if you have 3 houses, they're going to be like, sell 2, support yourself on that money, live in the 3rd, and then if you run out, then fine, we'll pull you up. But why should the workers who don't have 3 houses be paying for that, right? For you to keep your 3 and have them pay for your healthcare. If you get SSI, you should not lose Medicaid, period. If you have resources that when you get your SSI, somehow you're now over a limit. I find that to be remotely not even sure if that's possible, Rachel, because the SSI amount can be reduced if you have other income. So let's say you have $500 free worth of income from another source that's countable. Say a trust fund sends you $500 cash. Then your SSI may go down to $500, but you still have almost $500 left from SSI, given that SSI is almost at 1,000. So you still get the SSI, still have that latch on to Medicaid. Looks like you're getting Medicaid without the SSI, so you're in a state that does that. So that's good. And there should be there's nothing implicated there with any new law that's passed federally. Whatever your state decides to do, who's the one that actually controls your Medicaid, you'd have to kind of look to them about that. Thank you, Michelle. Michelle can hear. Ulysses. Yep, can hear. Good. Thank you, Maeve. Hello again, Christina. Good afternoon, AF Vet. And Dimple's here from Ohio. Dimple's in the house. Art of Practice. Good to see you again. Art asks, how helpful is it to have 5 to 20 medical visits per month? That would be therapy, specialists, labs, etc. With facilities only open 9 to 5, Monday through Friday. Are there any rules regarding excessive visits necessary for treatment? There are narratives where the schedule of where it can't be changed up to some other schedule, or that, if someone's mandatory treatments interfere with what would be a work day, not necessarily 9 to 5, because there's many shift jobs that are not 9 to 5. There's night shifts, there's that other shift, 3 to 11, then 11 to 7, all that. So it's not going to be, definitely not carved in stone. There are some that require specialist treatment. The more specialists typically don't offer Saturday, I don't think, Saturday visits. And if it's where you have to see your specialist every month, maybe it's for an injection, and the only time you can get it, I literally have 2 big dogs making my chair not move. That could be if it's an hour that you'd be out of work, maybe not so much. So it's really going to depend. I have used it when it's been a pervasive, no ifs, ands, or buts about it. You have to go at that time. Physical therapy doesn't tend to help because they usually have evening hours and sometimes Saturdays. So that might not be one they jump on as much. And I'm sure some would say, well, you could do it on your lunch break, but I don't really find that to be realistic, because A, you need to have lunch, and B, getting there, getting back in your seat, assuming you get a whole hour for lunch, would not be possible. So I definitely think you should. And labs, usually those things open very early in the morning, and you can go there before you have to go to work and maybe only be a few minutes late. So I would think more about the specialist appointment, the kinds of therapies that are not available outside of 9 to 5. I would focus on those, and the actual duration as well. I've had people with like IVIG treatments that are a couple hours or longer in duration, and they wipe them out for 2 days after from physical consequences of the chemical going in them with the IVIG. It's almost like a kind of chemotherapy or something. Between having to sleep for 2 days, then having a lingering headache for 3. If those things get documented in the medical record, so make sure you complain about them to your, I would say not just the provider that prescribes it, but to the PCP too. Get it all in there as best you can to hopefully see that it comes out in the records that they actually mention it. And that can all help contribute to the argument that the mere mandatory treatment would be so invasive of a steady work week, notwithstanding my off-task time or the fact that I have to be absent because of excessive pain days or whatever. That can certainly add to it. Art goes on to say, how helpful is it to have 50 to 20 minutes? This is a repeat, isn't it? Oops, sorry. Sorry, Art. I just repeated you. Dimple says, what other options should I have done to extend my short-term leave from work? I don't deal with employment law, Dimple, so I really can't say. I'm going to happily pass on that. My employer had me set to return 4 weeks post-knee replacement, and I would not have my PT completed in their time frame. Again, you got to look, PT can often be done at other times. If you're rural, let's say you're really rural and it's PT, there is no PT in the area, and you have to drive an hour and a half to PT, which right there, you're going to be killing yourself, or some, an hour or even 45 minutes. That's not something that can really easily be done. If they are only open, Art was saying between 9 and 5 or whatever, just got to track all that stuff. But yeah, I mean, if you went ahead and asked your employer, one of my said, when are you going to have me back? They're going to give you an answer. I have reiterated this before, guys. Be careful what you ask for. You might get an answer you don't like. So sometimes it's better not to ask, and just, you're your own adult. If you're not going back to work, you're not going back to work. Once you ask a doctor their opinion and you don't know what that answer is going to be, 90% chance you're going to get an answer that is not going to be helpful to your case. So I always say, tread with caution when you're asking. It's true of anything too. I mean, we do this at trial. We don't ask questions unless we know what we know the answer is going to be. It's like a major tenet of litigation practice. Okay, Dimple goes on to say, I also have an appointment with a hand elbow surgeon in 2 weeks. I'm hoping to have the doctor to address my issue with working during this appointment. Again, be careful what you wish for. I am a proponent of going on the merits of the evidence. It is the most, and that would be like the organic treatment records. Don't screw with it unless you have to. When it's, for some reason, it's not going well, because this is the risk you get. You're out for another 4 weeks. I mean, remember, disability is 12 months. If you're not expected to be out for 12 months, none of those are going to help you. And they're also kind of screaming that it's not that big of a deal. Just be careful what you ask for. Daryl Smith says, hi, Daryl. I got my SSDI award letter. Woohoo. I think we learned this, was that last week, Daryl? Or the week before? The weeks fly for me. I have no idea. I have no idea what week it is, except that it is August 8th. It does not say anything about Medicare or Medicaid. Am I required to get? Okay, so SSDI does not make you, it doesn't, your award letter doesn't define whether you are eligible for either one of those. Medicare, you're not eligible for unless you've been disabled and collected 24 months of benefits. So your award letter isn't necessarily defining that. And Medicaid is your state-run welfare health insurance, which is not the same as Medicare, which is one that you paid in for. Still have the waiting period like most health insurances and other insurances. And in Medicare, it's that 24 months of back payments. So depending on when your onset date was, Daryl, and how many months of back benefits you have is how much you may still have to wait for Medicare. But you can always call if you're not sure when that date's going to be. But in a nutshell, it's the 24 month. We always say 29 months because you got your 5 month waiting period on SSDI, and then your 24 months of payments. But it's not necessarily 29 months, particularly if the 5 months was a while ago. If your case went a long time, I have many, many clients who, whether they waited to file and then we got them a pretty remote onset date established and proven, they have Medicare even before we win their case. They don't get it because the win hasn't been determined, but retrospectively, they're available now, and they could actually buy it for those previous months as well, which is another weird animal that I won't get into. But yeah, so the SSDI award letter, which I think you're saying it's from a judge, right? Yeah, he doesn't get into any of that stuff. He is only finding if you're medically disabled or not. That is the extent of his pay lane, and he has no reason to delve into what your state does with your Medicaid. There's 50 states, and they can change anything at any time. So that's that. Yeah. Maeve talks about off task. What about regular need to visit specialists such as PT? Yeah, I think we were just talking about that, right, Maeve? So I think we've been hitting on this. I don't find, since everyone and their mother gets PT, which I find to be a treasure trove of meritorious evidence in there, in the little nuggets of statements from the therapist, the scheduling of it is often not going to be huge, even though they are tasked with, if there's a presentation of significant interference with work that is not able to be altered due to treatments, I just don't see them hang their hat on PT, because people who hold their jobs go to PT. You see what I'm saying? A lot of people go to PT while they still have their job. So they probably use their sick days, their personal days. They do it after 4 when they get out or whatever. They take that evening appointment. So I just don't see it as being one that they are really, really gung-ho, like she can't work because she has PT. I just don't see it. It would have to probably be more than that. Just my perception over the years. And of course, every adjudicator could be different and every judge can be different. So, but sometimes when you look at something, you have to look at I think it's helpful to look at how pervasive is that course of PT in the general sphere of people who are able to work. And if it is pretty heavy out there and they're still working, you have to assume that the SSA is not going to find it to be a huge factor in and of itself. But if there's tons of other things, like you need dialysis 7 days a week, that can be very interesting, so it really depends. And that's not something that they can really totally change up on. Okay. Maeve says, I'm trying to get you up here, Maeve. Are there typically slam dunk conditions for SSDI that skip all the extra denials as long as it's clearly diagnosed on record, like blindness? Yes, if it's listing level, ba-boom. So you don't go through that whole lengthy step 3, the beginning of step 3. They'd say, does the person meet a listing? They review all the medical records. Remember, they have to get all the medical records, though. They review the medical records, determine if it's listing, and if it is, you're done. You've won. That's obviously very rare. Most things don't rise to the level of listing until they do. And you really want to win before that comes. I think it's better to win before your condition gets so bad as a listing, because that's really terrible, for the person. Asking because of a real sitch with a good friend. Yeah, so if it's listing, your friend is golden. Obviously, compassionate allowances are even more so than a listing. But a compassionate allowance is usually oftentimes a terminal condition. So terminally disabling for sure, and or terminal. Not fun. Hey, Maurice. Good to see you again. What is the difference between a CDR long form and a short form, and why do you get either one? Okay, one is long, more pages. It's almost like a full-blown 3368 and maybe a little functioning in there. It's kind of like doing that big whole step again, and they're going to really go to town more. The short form is much shorter, and it really just confirms some obvious things like, are you working? No. What are your last 3 visits? Well, this, has your doctor and you discussed going back to work? Yes. If so, did he say you could? No, he said I couldn't. Really some touch on it. And it's because they don't expect you to improve. They're just double checking that nothing fluky, wonderful happened to you and you've recovered enough or been able to get one of those really rare jobs that you actually got and are earning the money. The existence of the job is so rare that it itself being available wouldn't cause you to lose your benefits. But if you take the job, then of course you're no longer not working SGA. So the longer form is when they are not convinced that you might not have improved. Shorter form is usually when they think it's likely that you have not improved, but they need to make sure because it is possible. It's a matter of degree. Anyone who's taking care of their post-award case and follow up responsibly, if I may say, and they know they have not improved, you're generally not going to have a problem with a CDR, long or short. It's when if somebody drops the ball because they won their case and they're like, it happens sometimes, not wise, but it happens when sometimes people are like, well, there's nothing they can do for me. There's zero treatment. There's not even treatments that do anything to even help make it better. I just have to live with it. So why should I go back? Well, this is why. Because now there's no proof that it continues on to the level it did before, your comparison point. So I always say you got to keep that follow-up going with the specialist, even if it's once a year. You need to, let's say it's a musculoskeletal thing, get those updated MRIs every couple of years, whatever your insurance is going to tolerate, because can you get out from under my feet, please? Thank you. Yeah. You have a claim. You're claiming every month. So many people do improve, thankfully. But if you're not one of them, you want to make sure you can show that and not make it look like you have. Daryl Smith says, what does it mean it will be reviewed in 5 to 7 years? That's your CDR diary date, Daryl. So within 5 to 7 years, which I believe is probably dependent on staffing at the time. If there's an influx of disability applications because for whatever reason the population starts filing more claims, maybe it would be more in the 7-year because there's so much going on and, resources have to be applied. And if they're being worked on this, there's less for this. So it can stretch out. And sometimes we see it be way later than 7 years. I think some people here might have seen that. So it could be anywhere in between. But that is the best diary to get, really. 5 to 7 years means it's mine. Medical improvement not expected. But that doesn't mean don't do your reasonable under those circumstances that you've already prevailed. Reasonable follow-up. just to have it monitored, even if there's no treatment. And I would get those diagnostics updated if you have the power, for sure, because it's going to show that nothing improved. And usually, if it's musculoskeletal, we see it get worse. Daryl turns 60 in September. That's great. You've been over 55 for a while, and that was obviously you had the most, shall I say the word lenient set of rules applied to, and I don't know if lenient's the right word, but the most recognition of how more difficult it is for us older folks to bounce to other jobs if we couldn't do our old job. If we can't do that job in the last 5 years, they recognize that we have a bit of a difficulty adjusting to other work. I know I would. I say this all the time. Do the lawyering, that's totally cool with me. Probably not just this area, but others. But you throw me into where I have to become like a nurse or a doctor or a scientist of some kind or an engineer. And I was a math person, but when I look at my son, who's like in all these AP math classes, stuff I used to be able to do, can't do it. And could I learn it? I don't even know if I could learn it if I took 10 times more time than a 10th grader. Well, he's going to go into 11. I don't know, because the brain just doesn't work the same. We're not the same sponge we used to be. It's just not as flexible and capable. Just a fact. I recognize it. Yeah, Vet says physical therapy every 2 weeks because it's for dizziness. Okay, like a vertigo type of thing. Diagnosis of PPPD. And my PT wants me to have time in between appointments so that I don't trigger too much dizziness from too much PT. Yep, I can get that. Yep. That's the explanation you were given why it's only twice a month. That makes perfect sense. Perfect sense. Does he give you, by the way, like at-home things to do to help work that muscle, or just wanted? Mr. P, good to see you, Mr. P. I was denied and reapplying. Is there anything I can do or my doctor to win my case at initial? Were you denied after ALJ, Mr. P, and now you're reapplying? Did you choose not to appeal your denial and now you're just reapplying? Only because there's a difference. Just wondered. Is there anything I can do or my doctors to win my case at initial? I have a mental health claim and I'm working part-time. Your records clearly don't show that you can't work, and neither does your activity because you're working part-time. Now, that doesn't mean you can work full-time. But if your mental health records are just kind of innocuous and just say, hey, he's got some anxiety, he's got some depression or, ADHD, that doesn't really disable us. It makes us maybe not want to work, but it doesn't necessarily make us unable to work, particularly in the less stressful, less anxious fields. You know what I mean? So you have to kind of recognize the difference and see what it really is that prevents you from working full-time from a medical standpoint. And when I say medical, I mean mental or physical. And where does it say in those records that you need to have a very limited, if you're going to work, it has to be very limited and part-time, and why? What happens if you don't? Maybe that's what you should be looking for when you look at your records and see what they said. And then if that's not true, if you really, no, because I start to tweak and I start lashing out at people after a 4-hour shift. Well, is there proof of that? Get the proof, right? Talk is cheap. SSD cases. Talk is definitely cheap. Okay. Daryl says, if I have a court order to pay the X half of military retirement, would I have to count that money against my SSD? No, because even if you didn't have to pay any to her or him, military retirement is not work earnings. And SSDI is not welfare, where every penny given to you by somebody else or any income coming into you at all from whatever source may be counted against. You don't need it from welfare then because you've got it coming in this door. Your SSDI is insurance that you bought so that it would cover and pay you disability benefits, even if you're a millionaire. That's what you bought. It's like auto insurance. You get in the accident, doesn't matter how rich you are, you get to file a claim and get the money for the car. That's how that works. That's insurance. So that should not do anything to your SSD. You just have to fulfill your marital obligation. That's basically how that goes. Your SSDI is safe. You can win the lottery, millions of dollars. You have a military retirement. You can have retirement from any other source too. Christina, she says, please share the live video with family and friends. Thank you, Christina. Daryl says, he's talking to AFA. I'm going to not interfere with that little conversation. Dimple says, the place I work stipulates the time frame that they permit for medical leave. And if you are unable to return the date they suggest, you're considered to have voluntarily terminated your employment. Right. So you can either have them do it as a constructive, all right, you haven't been here for 3 months. Even FMLA would be kicking you to the curb. Those protections for your job is usually 3 months for FMLA. People do quit their jobs. They don't have to wait for the employer to do it for them. I mean, I'm just saying, some people feel like they have to well, my employer said I can't go to that doctor. You know, like you're the adult, you know, of your life. Now, if you're saying, well, I have to do it this way because that's the only way I get my pension, or there's, you know, that's different. That's different. But that's a contractual agreement you have with them. That's not how the law works otherwise. That's just, you know, the contractual agreement for those benefits, right? And it could even be you're trying to keep those health benefits. That's totally valid. Like, you have to do it this way or else it gets cut off the day you quit. I get it. So you want to drag it out a little bit and keep them hanging, keep those benefits coming. I would do the same probably. Dimple says, a note from the doctor is required for additional medical time off. Again, do you care and why? That's what I would ask myself. You might have good reason to care, particularly if you think you're going to go back. If you don't, and if there's no benefit coming to you from it, you can consider that too. But these notes are hurting you, obviously. I mean, they said that you could go back to work. Right there is a big piece of evidence that's not helpful. Doesn't mean the SSA is going to believe them, particularly if you get other evidence that says otherwise. But it is a piece of medical evidence from an MD, presumably, right? You're welcome, Maurice. Yep. Conversation. What do they say? My husband says all the time, this is an A-B conversation. See yourself out. He's so obnoxious. Daryl's keeping up with all his stuff. Good, Daryl. You're going to be fine. And you said you're 60. What's the chance of a CDR? You know, they have them, but chances are did you say you were mine 5 to 7 years? Yeah. 7 years, you are, I think you said you were 60, right? About to be. You're going to be of retirement age, and it's going to flip to retirement. It's not even disability, and there is no CDRs on retirement. So the time frame perspective is important too. Okay, Mr. P, you did appeal. You didn't reapply? You did reapply. I think you did reapply though, right? Because you said you're back on initial, right? Oh my God, these dogs are pushing my chair. Sorry, Daryl. Mr. P says, my doctor has already wrote me off to work only part-time. I hear voices and I think you're saying the severity make it hard for me to work. Okay. I do whatever I can to work less. I'm barely getting by. Okay. Now this is a symptom, Mr. P. The hearing voices, that's like an auditory hallucination. I don't know if you have visual ones as well. Sometimes, and this is a really, I don't know, something that maybe you can see if it applies to you or if it does, can it be reflected in the medical records from the psychiatrist and the therapist, hopefully jointly, that, you know how they have medications to try to quiet down that voice so you can focus and do other things like work a part-time job, which is great. I'm really glad you're doing it. I hope it works out for you because that extra income is going to be helpful to you too, even when you win your case, right? So some people, the medication works for a certain amount of hours and only a certain amount of stress can come into it. I'm of the camp that says all jobs have some level of stress. I know there's different levels and I know that's different, but it's also different people and how they react to even minor stress. So it might be where your part-time job, you can do it for X amount of time, but if you had to do it another 2 hours or 3 or 4, you would have your voices would get louder. You can't disregard them as well. You're distracted by them and you wouldn't be doing the job. So you literally are limited to, for medical reasons, only working, say, a 3-hour shift. Incidentally, when you're working part-time, I do think it is more effective in terms of persuasion when we are limited to shorter shifts and sometimes even like an alternating day schedule, because the next day is to regroup from that 4-hour shift we had the day before, get our mind back on us. True of physical too. Sometimes a 4-hour shift for somebody doing a light job or even a sedentary job with the sitting can really, they weren't able to go back and forth with the recliner and elevate the legs every 2 hours. And it does cause pain that takes them a whole next day to get back to baseline so they can go back and do it again the third day and do that shift. So I don't know. I hope that helps on the mental, Mr. P. If you can see if you can get really good, astute discussion by your doctor about what happens if you do more than that short shift and too many days in a row or anything like that. AF Vet says, if I lose my ALJ, can I hire you to reply? You could certainly fill out an evaluation form, AF, and we'll take a look at it and see if we have an opening in your particular area. We're kind of big into doing that and making sure we cover all categories and that none get over swamped at the expense of another, because we really try to help all kind of different areas. And if we overtake in an area, we have to cut back on someone else, and it's just not fair. So, but if you could go right now if you wanted and just fill out the eval form and say, I don't need it yet, but I just wanted to know if this would be something that you think would be open when the time comes. Because there are some that are almost notoriously open, and there are some that are almost notoriously waitlisted. So feel free to do that. And I will, if you mention your username on here, put it in there, they will ship it right over to me, and just say that Stephanie told me to get this to her to take a look. they do an initial eval, but it would come to me and it could just come straight to me. So, and if we're booked in that area, generally speaking, if it's the kind where just right now, for some reason it is, maybe we overtook and it might be open later, but there is still, like, we do the first in, first out, and we try not to be nepotistic about it. So there is that. And it is very particular. There are exceptions within exceptions and stuff like that, which I won't go into here, but it's for different groups that we do focus on. I will say veterans is one of them, but that is still always a very booked area in some of the categories within that whole category. All right, so Dimple says, understand, yes, trying to keep pay and benefits for a few more months. I get it. That is probably a good reason, of course, and I don't think you have a choice really but to get those doctor's notes, right, Dimple? So, it is what it is. It doesn't mean that once you stop, now those doctor's notes aren't saying you can come back in 4 months, 4 weeks or whatever, and then you can start building that duration of where there is nothing like that. Things we've touched on kind of before, I think, right, Dimple? Daryl, that's very sweet. Oh, okay. I appreciate you tooting my horn. I'm not going to read it out loud, though, because that would be tooting my own horn. But we have no more questions. Okay. Anybody? Don't be shy, because I will close it up, of course, if there's no questions. So we don't need to be sitting here, breathing at each other. I'm just going to slide this down and see if anybody has anything. Now's the time. Hey, Shub, what are you saying for? What is that? Shub is a awarded person. Yay. That was awesome. As is Daryl recently. Super, super, super. One thing I'm going to do probably a reminder video on, guys, because it came up recently. We talk about the function report and how I always say, a function report is not going to win your case for you. However, it can contribute to your losing at any stage in the game, because if you don't answer the questions, if you blow it off, it will be almost for sure a denial. Or if you make inconsistent statements, that affects the visual of credibility. Sometimes we make inconsistent statements and we don't mean to, and we're not being deceitful. It's just the questions are asked differently. We just happen to, our mind goes that way. We know what they are. And so it's easy for us to pick out inconsistencies and say, we have to make these understand this and this, and how this one is not saying anything different than this one. It's just worded weird, and we can fix that. But I understand that someone has, whether it's from my videos or somebody else's, I have a feeling, at first I thought it was mine because it was a statement about you can't win based on function report. And I do say that. But the part that was left out is, but you could sink your ship with your function report. So that makes me think maybe it was a different video by somebody else. And some people say function report is irrelevant. It doesn't matter one way or the other. And I believe that's completely inaccurate. I think all you have to do is look at ALJ hearing decisions and you'll see that it's completely inaccurate. You can even see it from DDEs. So the lower level will look at the function report and use it to support a denial. I think some of the people saying it's irrelevant, because even though you can't win on it, it is not irrelevant. You can be denied on it. I think some of the folks that put that out there is because they don't have a practice of assisting their clients with the function report. Same with the work history report. So how can you not assist them if you think it's relevant? Are you now subject to malpractice? I don't know. I just think it's a Shub. Are you kidding me? Oh, I think Shub just donated $20. That is really kind. That all goes to those things I was just referring to, Shub, about overfilled areas. The reason why we could expand some of them was because we could get more help, which is great. And it was all due to this stuff. Entirely due to this, I would say. So that is super generous. Thank you. So the sorry, I'm reading down here. I see Sharon Parrish is saying she can't get her question to send. I'm sorry, Sharon. Keep trying, maybe. But yeah, I will reiterate, function report is not irrelevant. Don't expect it to win your case, but it will sink your ship potentially, or contribute to the sinking of your ship, giving them fodder to sink your ship if you don't do it right. And what you put in that will be used by the judge later, one way or another. You want to give the judge more opportunity to grant you and give him citable references to the record where you did complain about something way back in the day and you did explain that you couldn't do that. Yeah. And the inconsistencies, I have to say again, thinking a function report is irrelevant and then therefore being okay with being inconsistent or looking really not credible or like that can't possibly be true and thinking you can get away with it because A, it's easy, and B, it's irrelevant. It's not. So this came up recently and that's why I'm bringing it up here, but I am going to do a video on it, I think. But I'd share it to you guys who are here, because I would say do not believe that at all. You know, we have the function report playlist so that pro stays who don't have representatives, they can use them. And if you ever want a piece of a function report question redone, you want more explanation on it, send me a message through or a post on any of these videos, and I will take specific note of that. Because I do want to go through and update some with new things that have come to light. Like someone has a specific thing they've asked me about, and it might be about number 10 or number 5 or whatever, and we can discuss it, because it's going to be something that other people come up with too. So that's why each number usually has more than one video, because different things about that number come up and people say, what about this? And we add it. But it is a pretty robust library of function report guidance. So, and it goes by number. So you don't have to watch a video on the entire function report when you just have a question about number 12 or number 5 or whatever. All right. I see Sam. Sam, I am. I didn't even see that you're a Sam, I am. And I said that. I guess we all loved our Dr. Seuss days, right? Sam says, hello, I'm on LTD, that's long-term disability, and workers' comp. My hearing was on 7/8. Will the decision take longer because of the benefits that I'm receiving? No. The judge has no regard one way or the other regarding workers' comp or LTD. LTD is going to have no regard on SSD to begin with. Workers' comp will have a consideration to be had and analyzed by the SSA if and when you win, to see if you have conflict with the 80% rule, in which case they're going to have to, other SSD will have to reduce its monthly amount for the months that are implicated by the workers' comp, or the workers' comp will, depending on how that works in each state. There's reverse states, this state. I don't follow any of it. Good old friend of mine from elementary school who was a workers' comp attorney, partner in a firm in Jersey. She's my go-to on everything workers' comp. But workers' comp has an implication. LTD does not. That is your private personal contract. It's private versus workers' comp, which is state input. Therefore, LTD and any offset they want to take is going to be between you and them. Like any other creditor, business creditor, it's your contract with them. Okay, I hope that helps, Sam. Hi, Sharon. Sharon says her daughter has her meds memorized. How bad is it that she recited them at her mental health CE? Honestly, Sharon, that would depend on what her problem is. If her problem is not memory, I don't think it would really matter. Or it shouldn't. I mean, let's say it was autism, and I don't recall what your daughter's specific problem is, but some people with autism have way better memories than the rest of us, right? I mean, look at Rain Man. Seriously, remember he could remember numbers. It is amazing. So higher skilled in some things, but not necessarily in the ones that would be needed for even the most basic, simple job. It's funny because they might have a skill that could put them in the rocket scientist league of some jobs, but because they don't have those other ones, say keeping a schedule, working unsupervised, not getting affected by their surroundings and getting triggered or whatever, you know what I mean? Those are the ones that eliminate all jobs, even if you could otherwise do a rocket scientist job. So maybe look at it that way. Try not to focus on it, I guess. If you can get your hands on, do you get your hands on the CE exam report when it comes out? If you have a representative now, I don't know that you do, but if you did, they can get it pretty easily because they presumably have access to the electronic file. Daryl says, how can I make a donation? I got to tell you, I'm not sure. I think there are buttons. If you look around, I don't really know. I don't see the same thing you guys do. It would be on the, I don't know, YouTube maybe. She would know. George Graham, happy Friday from Punta Gorda, Florida. Hi, George. Good to see you. I like it that you visit, and I still love the praying mantis. Praying mantises are very fascinating, guys, in case you've never studied them. They're very cool. Aunt Lizzie, hi, good to see you again, Aunt Lizzie. I'm in the process of getting SSI for my son. One lady got her child's decision in 2 months. Another woman has been trying for 26 months. What makes a difference in the time differences? It is I'm going to say that by and large, it is the quality of the medical evidence and how it depicts or doesn't depict a requisite level of severity of limitation, functional limitations from the symptoms that arise from the diagnosed impairments. That's really what it is about. So yeah, I mean, some people just have really mediocre records that just make the person look like they have garden variety this problem, but it doesn't stop them from, in the case of a child, it would be the child's definition of disability, the functional limitations in a child's life. And of course, if the person's 18 or over, they flip to the other standard of an adult life and working, because that's the difference between the children and adult in the system. Shub said he didn't know that LTD and workers' comp at the same time were possible. Sure, if you have a private, it's like automobile insurance you have, and you can still get workers' comp. LTD pays a disability benefit, workers' comp, which can be very temporary, can be very short term, whereas long term is when you're more long term disabled. One is a state government controlled mandatory insurance that employers have to maintain. LTD is not. Some people have an employer that doesn't offer it at all as a perk or a fringe benefit. Others have one that does, but you have to opt in and be willing to have a little piece of your paycheck paid towards a premium every month. And some, I think, outright pay for the whole kit and caboodle for every employee that's, say, full-time or been there long enough altogether. So it's like private sector. Although the public sector in terms of government employment also has LTD of some shape or form sometimes. So yeah, it can. And SSD does not care about LTD. I mean, you can use those records if they help you, but they are not going to, that decision is not going to detract from your SSD. Your LTD can sometimes, and this is the way it normally happens, in this day and age, most LTD policies purchased by an employer for the benefit of their employees use the term, added a term. This didn't used to be the way decades and decades ago, where if you get SSD, we get to knock down what we pay you, what that 60 or 70% we're supposed to pay you under your contract, down to whatever the difference is between the SSD and what we would have paid you. So if they were paying you $2,000 a month and your SSD is $1,500 a month, they now only have to pay you $500. And that is a personal term within the contract. You know, negotiation, presumably, the employers often go with this particular kind of contract because it reduces the premiums they have to pay to have that group policy of LTD. Back in the day, like I remember, early on, like 20 years ago, I would tell my clients I go, get a hand on the policy because you might have had it back in the day when this wasn't an everyday way they did it. It was like, it seemed like it was later in time that companies started saving money by having the cheaper version of LTD than the full blown. The full blown being you can get both SSD, LTD, and LTD is not going to say, under our agreement, we're going to offset what we owe you. We're allowed to subtract that. And you get both. And you live a pretty fine existence financially. But those days seem to be over. Now, if you have LTD that you bought personally and you didn't buy that particular term yourself for a cheaper premium, then great. You gambled well, because you thought you might get disabled. Maybe you had a strong feeling about it. You bought the LTD policy. It came to be, and now you can keep your SSD and your LTD, and there's no offset because you didn't buy the policy that had the offset. We get what we pay for, right? Kitty says, I recently turned in my first CDR, and I'm worried about missing that 10-day pay request if I don't check my mail. Oh, I know, but checking mail is worsening my condition. Any advice? Do you know the form number? Form number for what? You could send a letter. In fact, why don't you just prepare the letter now just in case? And I would fax. You have to find out though whether your CDR ceased you, when that happens. And I agree with you. The 10-day rule is not fair. It should be at least 30, in my opinion. Now, maybe you guys can answer this because you guys all have access to your Social Security accounts and your independent claim or in a post. Does anybody know if when you go through a CDR and you get denied and you have to decide whether to appeal, which you probably will, and you get that little note that if you're going to appeal and you want your benefits to continue pending that appeal versus being cut off, you need to notify us within 10 days. That's what Kitty's referring to. Does that cessation on CDR that triggers that 10 days, is that something they put up in your account? And if it is, and it should be, in my opinion, that should be a priority tech thing worked on. Then you will pay attention to your phone, your notifications, always be checking your SSA site, and hopefully they actually give you texts or something to say, check your site, there's something in there, just so you have notice to check. I don't know if that's the case. I'm hoping maybe somebody here does. If you do, please let us know. And if anybody ever took a picture of it, a screenshot, even better. A screenshot can be worth 1,000 words. Yeah, checking your mail. Maybe you can get someone else to check it for you, Kitty. I assume you're talking about the hard mail at the mailbox. Do you have to drive to it? Or is it walking? You have difficulty walking? Maybe you can get somebody, your neighbor, to get your mail when they get theirs. Like if it's at the end of your driveway. I happen to have where I technically can walk to mine. We're in like this gated community and all the mailboxes are together. It's a pain in the rear. I'd like to think the mailman has to come to my house, but he doesn't. It's really annoying. Okay. But anyway, that's something it would be nice for you to know if it's available online so you could just check it, right? Or you'll be given notification. But I would say if it was me, I would be checking just because I'm anal. I know that's not really good for stress levels, but just saying it like it is. Aunt Scary Sherry. Hey, Aunt Scary Sherry. From start to finish, what is the average time for decision on an SSD case? That will depend on your area, and they actually have it up on your thing. So if you have a case, it usually says they expected time for this. Well, they usually go by stage, I think. I have some in and out, done in 6 months, some 3 years. So it really depends. And it used to be longer. There was a time when by the time you got to have to appeal for an ALJ hearing, you waited 2 years for the hearing. That's after you've done all the other stuff. So that was probably, we were looking at 3 years. So I probably have a couple that are, I might have a couple that are like 3 years long. Most of them are in the 2, still under 2 years. But it's not, there is no rhyme or reason, and it's changing on a dime because every time they improve something, it's been coming down a little bit, and now they're actually reporting on some of the improvements and how it's reduced the time frame, but it's still long. It's not where it needs to be. So I just hope for the slow and steady wins the race, get it down, and get it back to some semblance of normalcy. Historically, initial and recon were fine, and ALJ was the long one. That changed around 2019 when they got ALJs down to like 5 months, at least in my area. It started to, then we got hit with COVID, and that, of course, rocked the boat. Initial and recon was never the problem, and now it's initial and recon. But that too, as I just reported on numbers, is starting to come down now that kind of technologies are getting utilized where they weren't before. Knicks for life. I assume that's the sport, basketball, right? 44 years, going for another CE, physical and mental, denied since 2018. I have lumbar radiculopathy, asthma, migraine, anxiety, and depression. Just diagnosed with severe sleep apnea, fibromyalgia, and MND. You got a lot of stuff going on. You have a very difficult age that is not favored for disability with SS, but if you can show enough. So I expect that you are seeing a back specialist who's a neurologist, potentially an orthopedist for that as well, a pulmonologist for the asthma, unless it's not a big deal and it's well controlled. And then it would just be PCP. Migraine, I would expect another neurologist, potentially a different neurologist who specializes in migraines, Nicks, because they are out there, and that your migraine treatment reflects a severe migraine disorder and not just a migraine disorder. For instance, Botox is generally not going to be supported by insurance unless it meets the criteria. And maybe it's not even allowed to be prescribed unless you have 15 migraine days a month. That is a significant amount of migraine, particularly if it's not like, oh yeah, no, you pop an aspirin, it's gone in an hour. That's not really the migraines that we're talking about. We're talking about the ones that wipe you out, put you in bed, cold, dark room for hours and hours, not necessarily immediately remediated by abortive medications, and certainly the preventives don't work all the time. And that's, I think, when the Botox starts to kick in, if it's frequent. So that is something that I would be expecting. And with the anxiety and depression, is it high enough to warrant medications, or is it not quite that bad? Do you have a therapist that you see weekly, or is it not quite that bad? If you're going to get on medications, is it just by the PCP, or are you seeing a psychiatrist for those medications? Which, by the way, when it's a psychiatrist for it, guys, it's usually medications management only. Not always. Some psychiatrists actually do the therapy too. I think that's kind of ideal. But otherwise, it is just usually medications management. And I usually see quarterly, even infrequent as quarterly for the psychiatrist and the medications visits. But that's when you definitely want to have that therapist for all that other discussion about how the anxiety and depression affects your day-to-day. And you talk about it at every session. Severe sleep apnea, obviously that could be pulmonary, and the sleep specialist area of that. Fibromyalgia is, we have some discussion on this recently in a couple videos. One is already out and maybe another one's coming out. That is a hard one because there's very few specialists. Sometimes if there is, it's a rheumatologist who is fibromyalgia literate and not biased against it. And then there's some rheumatologists who tell you to go see your shrink. It's really not treated appropriately by some. So that could be a struggle. But so if you have to do your PCP for that and get it, make sure it's diagnosed officially and on what date, and have a copy of that record when it was. That could have been the trigger point tests or something different that they are now accepting, because you can't really get blood marker tests for it. And see where that brings you. But 44, it's going to be hard to prove that you can't do a low stress, simple, skilled, minimum wage job that doesn't involve perhaps being around people whose jobs exist. They're kind of always going to say you can do sedentary or light. It's just what we see. It's hard to win. I mean, I have my 40-year-old cases, and it is a mountain to climb. So you have to be really, really willing to go the 9 yards with all that treatment and specialists. You've been trying since 2018. Your other concern might be you're no longer insured for SSD unless you've been working part-time, perhaps under SGA, to keep those credits coming in next. So if you're no longer insured for SSD, SSI is your only alternative, and then you have to be poor enough as defined by the SSI rules. So look into that and see about whether you can keep up your credits. Can you pull off a little bit of part-time work and do that? Things to think. Next goes on to say, what are my chances fourth time seeing an ALJ? I'd say if you haven't changed up what you were doing before, your chances are probably no better. I do kind of feel like the fact that you've been trying for so long, assuming your medical records are decent, I think the fact that you try so long and so hard might speak to an ALJ that, yeah, this might be one of those cases that is not getting better and it's not overblown or an overestimation of the limitations. That is only a crumb. It's not going to defeat a lack of good medical records, Nix, but sometimes I get the impression that sometimes the keep going puts a face on it as well. Shub says, oops, LTD was through employer. Are you still getting it? Is it reduced? Do you know what's going on with it? Usually they want to know everything about your SSD case. They make you apply for SSD if you have LTD because they know that they can save money if you win it. So they want you to apply. Sometimes they send you to one of their little outfits that get paid win, lose, or draw. I don't even get that, so they'll file the papers, but they don't really give you advice or work it up at all. But yeah, you should find out. And then it's very interesting. You can do kind of an analysis like, well, if I get the offset with SSD, because that's what the policy says, my SSD is 2,000, my LTD was 2,000. I'm not going to get anything extra from LTD. And then you get your back benefits from SSD that cover the back months of when you did get LTD, and LTD says, hey, remember, we have these back benefits going on that we paid you, but now it turns out you got SSD for those back benefits once they find out about it. And they say, you got to pay us the SSD. Well, you got other creditors probably too. And it's not necessarily clear that your LTD is required to be your top priority of creditors to pay, or obligations to keep your life going on a smooth and even keel. If you need a new roof on your house, what comes first? Honoring that contract or putting a new roof on your house? People in businesses make those kind of tough decisions every day. So I would say, think about it. If that's up your thing. Now, if you have more to gain from LTD, because it's not going to be a total wipeout, or it's not just a 2-year LTD policy, which is going to end in 2 years anyway. Do you really want to send that $50,000 back then? Is that going to be my priority, or am I going to pay that credit card that's going to otherwise rip my family apart, or that back mortgage that I'm now 4 months behind on? Things to think about. And speak to your financial advisor and or your personal lawyer if you have one. Definitely do your due diligence. I'm just throwing the ideas out here for things for you to consider. I'm not giving you the answer. Aunt Scary Sherry says, if you notify your senator or congressman about your case, how long does it take for them to do something? Depends what you ask them to do. If you ask them to do something that they cannot do, probably wait forever. I just contacted one the other day. I think it might have been like a week ago, but I heard back, maybe it was early in the week. I'm trying to think, because I was in that hospital hotel bouncing back and forth. The days kind of run into each other. But I did contact one, and it was a little frustrating because it's about a unpaid attorney fee that the SSA didn't do the fee approval on, and we're just waiting on it. And it was frustrating because I contacted my congressperson, and the team member that got back to me said, okay, so we got your release, but we need the one from the constituent. He's thinking he needs something from the claimant that is no longer a claimant, is now a senior retired person. That's how old this is. I do happen to have a nice friendly relationship with her, out of state, not one of his constituents, far away. And I'm like, listen, I can get that because we became friends after years of 2 different cases with her. But you don't need that. I go, in all fairness, most attorney-client relationships with SSD end when the case is over. It's over. No one's supposed to be friends with their lawyer or vice versa. It's just not, not typical. It happens sometimes. And this was one of them. And, it's an older person, a senior. But the funny thing is, that's not your constituent, number one. And number two, why should the fact that I've been harmed by the SSA mean that you have to go get permission from a claimant who's no longer my client and not related to this problem? What if we didn't have a relationship? What if someone is no longer on this earth? What if we don't have contact information? Someone moved, ridiculous. So I sent an email today saying, listen, you got it all wrong. Reread, tried to say it nice, but it's getting maybe a little, I don't know. But, it's like, no. You can't expect a claimant from a 10-year-old case to have to sign off on something. She doesn't have to do anything. She will. I know she will, but that's not the point. That would normally not be the case. And so should everyone who's been harmed by the SSA not be able to get addressing by their congressperson because some other person 1,000 miles away is no longer in the picture? Makes no sense. Anywho, I usually, historically, I would see them get back within days just to say, we got this, but we need this release. Or do you have any documents to blah, blah. Usually very good. I feel like it's been less good the last couple of years. Not sure why, but and you can only ask them to do things like get a cog out of the wheel. They didn't do this step in the process. We're still waiting to be connected to the electronic file, or the claimant is saying, my case is 3 years old and I haven't heard a word from SSA. Can you light a match? It's just getting the cog out of the wheel. It's not making it's not making a decision of substance. It's just getting the SSA to do what it's supposed to do so it can make a decision. If you get the difference I'm showing you. They're not allowed to put their thumb on the scale of justice or anything like that. I guess you got my point, right, Shub? I'm like, just, I mean, if you have 3 credit cards that want something and them, who takes it? Anyway, okay. I was trying to be subtle, but I'm glad you got what I was saying. Valerie, hi, Valerie. Long time no see. She's talking to Auntie Lizzie, I think. Okay, good. I'm not going to intervene in that little conversation. You guys keep it up. I love the interaction. Valerie says, good morning to all. Hi, Valerie. I'm glad you could be here. It was nice to see you on the posting board today. So I'm glad you could stop in. Shub says that grandma told me 50 years ago, can't squeeze blood out of a turnip. Right. Didn't we say something about a stone? Can't get blood from a stone. In the legal field, we call it someone is judgment proof. Yes, because commercial enterprises generally cannot garnish your Social Security. So there is that. Did I say it was upcoming at some point recently or upcoming? Is that discussion about bankruptcy, just from an overall perspective on some people are just so afraid of the thought. They'll go through debt consolidation for 10 years and come out twice as broke and twice as in the hole because the bankruptcy word is like cancer. I think we got to get off that. It's a law designed to provide fresh starts, and I don't know of a better reason than medical disability not being able to work like you always did. Just personally, if we were going to put morals on it, which I don't think we should. So just laying it out there, guys. And I'm not married to a bankruptcy lawyer or anything, I promise. I'm just saying I have heard nothing but positives, and I hear them a lot. Oh, okay, yeah. Definitely they will pass that on to me, and we'll let you know one way or another. So at least hopefully things won't slide south for you, AF Vet. But you'll know, right? If it's like for sure, we'll manage, no matter what, you have a spot. Hi, Sharon. One of her claims is her memory. She's been taking most of the same meds for a decade. All right. Yeah, that's not as good. Right, Sharon? If she can memorize all her prescriptions. There's different kinds of memory. She can memorize a list if she takes the time, but she can't quickly memorize a 3-step process or a 2-step process, or distraction will come in and interfere at any time of the day to get her off that 2-step process. And I'm thinking about unskilled jobs that they talk about, the simplest of the simple, just 1 2-step jobs where the tasks are no more than 2 steps. Probably would have been better had she not done that. Sometimes people try to impress the doctors. I'm like, what are you doing? But it's not necessarily. I mean, if you have everything else, if all the stuff lines up, that probably won't matter. Not sure, given what you said here, that it will help, though. I get your concern, Sharon. I do. All right. How are we doing, guys? We're an hour and 20 in. I should probably have some water because I can feel a dry throat. I don't know if there's any other questions. Anybody need anything? Anybody? Oh, my goodness. What is that? Daryl. It says Daryl, $50 super sticker. Okay. I don't even understand that, but that sounds hugely generous. Thank you, Daryl. Seriously. I'm thinking one of these days we'll add one more, I don't know how to say it, slot into one of the, I used to call it my 1%ers, the cases that no one will take because the chance of winning is 1%, and I always say it's only 1% if it's not worked out properly. Then it goes up to maybe 40%. So why can't some of me and my colleagues take the 40%ers? Because 4 out of 10 people would win when they otherwise wouldn't, right? At the 1% level. That's why we do it. Disabled people can fall into the 1% chance of winning group through no fault of their own. And it's just the way it is. That's what we try to take. And that was the end up mission. If you guys ever watched the mission statement on this channel, to try to do that, to give back and make sure more can be taken. I've always taken them since I started, but we do have to have the balance to keep the doors open, lights on, and all helpers helping. Kitty says, oh, did I miss somebody? I did. Sorry. All right. I'll hit you, Kitty. Give me a second. I like to go in order. George Graham, I get my mail. Wheelchair. Guess CDR is coming. I hope not. Get my mail. You mean you get your mail in a wheelchair? I don't know what you're saying, George. Sorry. Scary Sherry says, my case dates from 2022. I forget what you were saying. By the way, on the replay, guys, all these like pauses while I'm scrolling will be gone because we do that. We have that little software that pulls it out. Thank goodness. So replay is not. I can't even find out what you were referring to, Sherry. Maybe you were talking to you're okay. Wow. Okay. So oh no, that's Aunt Lizzie. I'm mixing up the aunts. We've got Aunt Lizzie here today, and we've got Aunt Scary Sherry. Whoops, sorry. Here you are, Aunt Scary. If you notify your senator or congressman about your case, how long does it take for them to do something? My case dates from 2022. Okay, so your case is 3 years old. Sherry, where is it now? Do you have an adjudicator who is sending letters? That means they're on it. There is nothing to get your senator to do. If you don't have an adjudicator, you have not gotten a letter for a function report or anything like that, it depends where you're at, then possibly you don't have one, and maybe you've been waiting a year for one, and they can sometimes say, hey, this one looks like it, is there a reason why this one is a year, but maybe some people are getting adjudicators faster? It's almost like something fell into the crack. That's when I would use that. All right, I'm trying to find out where I was now. Okay, Valerie Woodson. Okay, hello again. I was approved for SSDI. Hello to you, Valerie. This past January back to July of 2022. Woo, woo, good for you. I did recently receive back pay from July 2022 to February 2025. Now just received SS letter stating I was no longer entitled. Why is that? What happened? That's interesting. What happened? Were you working? What's going on? Kitty says, so it sounds like there is no form for those continuing benefits then? There might be. Everyone I know just sends a letter. Do a Google search. SSA form for continuing benefits pending CDR. There could be. They have forms for a lot of things. But yeah, you could just do a letter, and I put in the subject big and bold, request to continue benefits pending appeal of CDR denial. It's a notice. It's because all you need to give them is a notice. So they've noticed that, and then they're supposed to act on it. I've tried to log onto the SSA website, and it freezes during the authentication part no matter what I do. If it freezes, do you think that's your device? Can you try it on a different device? Are you doing it on your phone? Can you do it from a computer or someone else's phone? The freezing makes me think it's your device and not the SSA website. Unless you tried maybe always in one day only and they were having issues that day. But you say no matter what I do, maybe it's your device because everyone else gets on. My clients are always sending me screenshots. Hey, it says this. I'm like, I don't care. I don't say I don't care. But you know how you guys were talking about those very bizarre messages like, I was on step 3 and now apparently I'm on step 2. What does it mean? I'm like, it's nonsense. It means nothing because that doesn't make sense. So it's just some sort of miscommunication, but everyone was getting them a couple weeks ago. Remember everyone here was saying? So I'm usually like, if they show me a screenshot that says a decision was made on so-and-so date, and now it's in final non-medical review, I'm like, okay, so we got a decision and we don't know what it is. If it says a decision was made and now it's in federal quality review, then I'm thinking I'm a little hopeful. But as of now, nothing's ever carved in stone, as usual. Valerie Woodson says, for disability benefits because I reached full retirement. Oh, no problem. All right, I'm relieved. So Valerie was saying to us, I'm just going to reiterate this, Valerie Woodson, so that everyone can see this. She was approved for SSDI in January, back paid in July of 2022. She did recently receive her back benefits. Now just received SS letter stating I was no longer entitled. And then she continues on to say, no longer entitled to disability benefits because I reached full retirement age. Perfect. You got everything out of it. You got to collect full retirement amount in the name of SSD. And then you hit full retirement age. So you got all that back benefits you wouldn't normally get if you had to wait till SSR, full retirement age. If you were hard up, maybe you would have had to take early retirement. And then you perpetually have that early retirement amount. Even now at 67, I guess you are maybe. You are what you are personally, but you are no longer considered a Social Security disability recipient beneficiary. You are now a Social Security retirement beneficiary. If it's name only, your amount will stay virtually the same, and you don't have any of those SSD rules. There's not many, but working, for instance, if you are concerned about working and CDRs, you don't have that hanging over your head because you're in retirement. You're in those golden years of retirement, Valerie. So enjoy them. And you got your back benefits. So that might be a little nest egg that otherwise was not going to be there. So that's the beauty of that. You got that lump sum back benefits. I guess maybe you got a couple months of SSD before the retirement date. And then, yeah, you're just not disabled. You're not on disability. You're on retirement. You're not collecting from the Social Security Disability Fund anymore. You're only collecting from the retirement fund. How's that sound? I think it sounds good. My opinion. Jube says I was approved for SSDI in 76 working days. Yes, it was phenomenal. 30-year truck driver, osteoarthritis in both knees. Yeah, so couldn't do your prior work. I forget how old you are, Shube, but I think you had a grid application. Do the prior job. Maybe they said you could only do sedentary work, but the truck driver's skills do not transfer to any sedentary work. That would be a grid app. It is beautiful. Okay, interesting name. Looks like a company. Graphics, etc. Is that what we are? All right, graphics. Graphics says, and it's nice to meet you. Can I, when a claim based on the fact that I can work but no one will hire me, let alone keep me as an employee because of my disabilities? Well, the fact that no one will hire you is not a good answer, and it's not going to be a good defense. I think this is what you're asking. First of all, what disabilities are you talking about? Do you tell them about them, which is none of their business? For most jobs, we've talked about this before. You know, I don't wear my negatives on my sleeve when I go try to get work. You know, if I know I can do the job, it's none of their business. Or, I mean, you say you can do the work. It makes zero sense. And if you can do the work but no one will hire you, then you could be a self-employed person doing work. So then you don't have to worry about anybody else's opinion of you. So you have to kind of be a little more specific here. Disabilities. What are the disabilities that you say they won't keep you because of your disabilities? They won't hire you. That means you told them about your disabilities, which is kind of loose lips sink ships. Why won't they keep you? What happens? Are you sure you can do that job sufficiently? Because if you can do a job sufficiently, most employers are begging for competent workers, particularly with everyone living in their mom's basement and not doing any work. You know what I mean? That the lower generation has a higher propensity for that. Not to knock all younger people, not all Gen Xers. Oops, sorry, Gen Zers. I'm a Gen X, right? Not all millennials. I know some great ones. I think my kids are Gen Zs. They're too young for me to make a judgment call yet. We'll see. But they're not living in my basement. I got news. Okay. Daryl, I appreciate that. And soon we'll probably be bumping up the number of slots in that area I was referring to. We've done it twice already since we've been doing this. So it's bigger than it ever was. I know that sounds small, guys, but it's a lot of hours and it's a lot of expense. When it's going to be pro bono, or when 60% will be pro bono, because you're bringing a 1% or 40%, or sometimes I actually think we're like at 65%. I don't really want to say because I don't feel like we have enough of a cross section, if you will, or enough of a pool of them to really make a sound judgment on that. But it does have a pretty good, not one that I could live with without the other ones. You need those much higher rates. But okay, let's go to Maeve. Hi, Maeve. The psych exam did the standard memory test. And I have to say it was not realistic to life. Oh, I know. I think you're probably talking about CE exam, right? They gave 4 nouns and said up front I was to remember them. 4 to 5 minutes asked for them. 4 to 5 minutes asked for them. Go on and ask me to 1/2, 1 of 2, 2 of 2. Remember phone number, even 3 to 4 digits. 30 seconds after I looked at them, much less 5 minutes longer. Don't tell me you will ask again. I'm not sure if you're saying you were able to do the 4 nouns. They gave you 4 objects and then 5 minutes later asked what they were, and you're saying that was no problem. Well, for a lot of people, it would be a problem. So I'm not sure what you're saying. A lot of people that don't have like the retention, that would be a problem. They might only get 3 out of 4. They might get 2 out of 4. Really, really bad retention. They won't remember any of them. Like, what was that? The numbers. Did they ask you to remember a phone number or just 7 digits? Oh, they showed you one and asked you to remember it 30 seconds after you looked at them. No, much less 5 minutes longer. All right. So it sounds like you didn't remember them the numbers 30 seconds later. And you certainly wouldn't remember them 5 minutes, right? Yeah, that's hard. I mean, honestly, a lot of times memorizing those things does not come natural. And I use memory tricks to remember stuff. And you're certainly not going to have it in your mind to use a trick when you're in one of these CE exams. So the chance of not being able to do that, particularly when you have a memory issue with that, I think is pretty high. But anyway, but some people do it. I do have people that do the 4 to 5. They don't have that problem, and theirs is all physical. So it's just to see where you're at. Aunt Scary Share has been in recon since October of 2024. Yeah, 9 months. What are we at? 10 months? 10 months. It's not, have you gotten letters? Does your adjudicator call you and ask for updates? I assume you're self-representing. That's how you know if there's someone on your case. If not, but you had a letter before, but you haven't heard from them in 6 months, I suggest you call them. Find out. Ryan Kivel or Kival. Which one is it? Can you talk about the different scenarios to which an ALJ will determine an onset date? Is it based on the apply date, or can medical records be used to decide? Oh, yeah. Certainly not the apply date, unless it's SSI. Then it's never before the apply date. It's apply date or after. But let's say we're talking about SSD. You have an alleged onset date, AOD. That's what you put down early on, and or the SSA staffer put down for you. Hopefully it's the one that should be. They will look from that date forward. Were you disabled on that date or any date forward? So you don't have to tell them to look at each date forward. They will look at every day forward, and they will stop at a date last insured if you have one already. If you don't have one and your date last insured is in the future, which is ideal, they will look to the present. And they will decide if at any point that evidence becomes strong enough to show that you became disabled under the rules that apply to you from doing all 12,000 jobs in the economy. Okay. It's pretty straightforward for an ALJ. The apply date will not affect the ALJ's review on an SSD case, only on an SSI case. And that's because you apply on this date, but you could be saying, I stopped working 6 years ago because I was in this horrible car accident and I was demolished and I never could get physically well enough to be up 8 hours straight, to do even a sedentary job or whatever. And it could be that you never applied to last year because you didn't know you could. See that all the time, very remote onset alleged dates. And you don't have a DLI anymore because after 5 years it ran out. So your DLI ran out last year. Your alleged onset date is 6 years ago. So what do we 29? He will look back to when you allege, even if it's way before the apply date. And he can find that you were disabled back then. It is the later on the payment office that will apply the rules about how far back the payments can go based on when the judge says you're disabled. They're never going to pay you back to them because they can never pay more than 12 months worth of payments that precede the date you applied, which was 2019. And then the first 5 months of disability that he decided back in 2019, you were disabled. 5 months are the waiting period. However, I think they don't actually take the first ones when it's that remote, but they take the ones 5 months before. I'm going to get this wrong, but I know that they can move it around. But they'll do it the 5 months like before your application date. I think if you were disabled for those, I think. So oftentimes you're going to have back benefits regardless, particularly if you have a remote date, because you're going to at least have those 12 months before you applied, because those are the ones they can pay you, even though you hadn't applied yet, because he found that you were disabled not only those dates, but several years earlier. Does that make sense? And the 5 months is wrapped in those months that have already passed, the 5 month waiting period. And that's always nice. Daryl says, Shub, I believe in what Stephanie's doing. Just want to help someone who needs it. I love that. That's cool. I really appreciate Daryl. That was really generous. Both of you were very generous. And Shub, that's not your first time doing that. You've done other things, and it's just really sweet. Brian says, hello, by the way. Hello to you too, Brian. And Scary Sherry says, what does non-medical review mean? It means squat, just for the record. We have videos on this, Sherry, because a couple years ago, maybe 2 years ago, I feel like it was end of 2023 or 22. Let's just say 23, just to be safe. People were getting these, suddenly they're getting notified on their phones and stuff with their online account, but not on paper. We have found that sometimes on paper, a decision has been made and now you're going to non-medical review. Well, the implication is I won the medical part because there is no need for a non-medical review if I haven't passed the medical at all, right? Everyone was getting misled. It was really disturbing because it was upsetting because then they get the letter saying, we found you not disabled medically. So I would not get any kind of excitement whatsoever for this, except now you're anticipatory of the fact that you have a determination made and you're going to find out soon what it is. That's the only thing that's good for it, unless you already got an ALJ decision that says you're disabled on so-and-so date, because that is the letter that says you're disabled. So it is ridiculous. They need to fix it. I've been whining about this probably since right after it started in 2023, because people were saying, I got it in the hell. So what looks to be good news, and you must have won on medical, because why would they send you to see if you're still insured for Social Security disability, the non-medical, or if you have alimony that you owe, if you haven't even won disability? Like, it makes no sense. All right, enough said. Kitty says, that's awesome, Daryl. Yeah. Thank you, guys. Yeah. Oh, yeah. Shub says he's 57, not getting back in the truck. LOL. Yeah, I'm 57 too, Shub. Oops. But I'm going to be 50. 2 weeks? Oh, yeah. 2 weeks. Woo-hoo. Gotta love those years. I just want more of them, right? Okay. Graphics, you're welcome. Oh, this is awesome. Daryl says, due to your advice, I do not need a responsible payee. He means representative payee. I'm really glad that all worked for you. And remember, if something changes and you feel you do, you can always do it then as well. But I'm glad if you felt strongly you didn't, you stood up for yourself and just didn't let them make the decision without you putting your 2 cents in. So I'm really glad that helped you do that. It makes me feel good, Daryl. Truly. Maeve says, yes, 4 nouns you can envision. Yeah, like objects, right, Maeve? And a long pause to memorize. I get that really bad memory has a problem. I'm saying, if you ask me a number, I would never recall it. So you're like, even on your best day before anything else happened, right, Maeve? Yeah. A lot of people, I think the numbers are never going to stick. Yeah, I'm always doing memory games with numbers. Like, how did I memorize my kids' phone numbers, with cell phones these days? But sometimes you really want to know certain things in your head too. If my phone goes out, I don't have that phone number, and those are my kids, right? Husband's is really easy because we both had these phones for like 20 years, but the kids are just more recent, and his is very close to mine, just the last 4 are different. Valerie says, so if it wasn't approval of disability from SSA according to their guidelines based on my medical, non-medical, but reaching FRA, which is full retirement age, guys, 67 for most of us nowadays, does SSA still consider me disabled? Have you turned your FRA yet? If you've turned your FRA, they have switched you. It's seamless. They do it. You're now retired. You're not on the ranks. The SSA does not consider you disabled. They consider you retired. And they're never going to know. Perhaps you get a new leg and you're back. You're not disabled at all anymore in real life. It doesn't matter because now you're just retired. You don't have to prove that you're disabled ever again for SSA. If you have other things that you're trying to get, that could be different. All right, an hour 45 minutes in, guys. Okay. Maeve says, yeah, she said dog, so I pictured my dog. She said car, etc. Picture a dog in a car with ice cream and a shoe. All right, that's a memory trick, right? I remember I was still a minor. My parents, were still married, and I remember my mom going to some funny show where they showed you a memory trick, and it was actually picturing a well-known path you take, and I think I did it up my driveway and up to these backwoods, and there's this hill, and then you put the objects. This is just the way this one worked. You put the objects at this list that you have in front of you, and you picture them each in a spot, and supposedly that would help. And I think it did work at the time. Yours kind of seems better though. You kind of made your own picture of everything in it, and if you have dementia, it's a problem. Not even dementia. Honestly, some people just aren't good at that kind of recall. So, but that's important to know because it can take out certain jobs. So passing it with flying colors does not take out those jobs. Something else might take out those jobs. Maybe they require a lot of finger use when you have bad arthritis or whatever. But so everything has a little point that people don't recognize too. And sometimes people try to double think it. I'm not saying you're doing this, Maeve, but I'm just saying generally speaking, sometimes the questions are, you're like, well, I didn't have a problem with that. Therefore, I'm like, well, that doesn't necessarily mean that you're not going to be able to prove you can't do certain jobs because certain jobs have other things that are needed that your medical evidence addresses. But it can certainly carve out other ones when the CE examiner finds that the person has moderately limited working memory or whatever they're going to call it, recall or whatever. If you randomly forget steps in your job, you're fired. Yes. And we were saying before, the skill levels of jobs, we have the lowest level, which is 1 to 2 step undetailed steps of a job. And that's the lowest. So if someone can't do that, they probably cannot do any job in the sphere, that big bowl of 12,000 jobs we have to carve out. That's a really low. That's really hard to prove that someone can't do that. And a lot of times CEs will not go there. But forgetting some, like you might have made, it might take out some jobs that are not unskilled. It might take out some semi-skilled from a cognitive thing, and certainly high-skilled. Would I be a candidate for SSI now? SSI is for poor people. At 65, you could have been eligible for SSI if you were poor. You didn't have to be disabled once you hit 65 for SSI. So if you're super poor, like let's say your Social Security retirement is only $500, it's under that $1,000 SSI limit, then you could get a little bit of SSI to tack onto that. That's assuming you have no other income sources, do not have excess resources that are countable. But usually, for most people with Social Security retirement, they're not poor enough for the very low level, the bottom net of SSI, because the SSI is already overtaken by the fact that there's SSD of a greater amount, or SSR. You were not eligible before. I can't really say. I mean, when you were fighting for SSDI, you presumably had no income. So the income wasn't what made you ineligible for SSI. It must have been your countable resources. Did you have a 401k? Did you have a piece of real estate that you didn't live on? Did you have more than one car in your name? Did you have savings? You see what I'm saying? Or if you're married, did your spouse have income? Okay, because that's what's his is yours, right? I'm just being funny with that, but that's true in my house. What's his is mine. But unlike the whole saying, what's his is mine and mine is mine, you guys have heard of that. It's usually the woman saying it. I will acknowledge that what's his is mine and what's mine is his. We are definitely unified in that way, which is awesome. Daryl's talking to Kitty, so I'll just let that go. Brian says, thanks for some clarity. I've been disabled vet. Oh, thank you for your service, Brian. You may have told me that before. We met before, right here. PNT since 2023, and I've applied for SSDI in 2024. Left HVAC, so heating, ventilation, air conditioning in 2016. Was a driver until 2023. Okay. Well, fingers crossed for you on your case, Brian. I hope you get the right result there. I'm always relieved, not that it's fun for you guys when you're 100% PNC, but I'm always relieved that you have a good income that's not dependent on SSD. It gives me a lot of relief. I mean, I have a lot of loved ones that are 100% PNC, and they can actually live a rather, well, in my opinion, luxurious life. Doesn't mean they're going around the world 3 times a year on a yacht. That was never my standard of living to begin with, but they can do a lot of things. They can go on vacation. I mean, they're usually bringing in $5,000, $4,000 or $5,000 a month on their PNC, and I appreciate it because Social Security retirement is never intended to be our only income. It wasn't designed that way. We're supposed to be saving. It's things they stopped teaching us in public school 50 years ago, that we were supposed to be doing this and teaching us how. That all stuff got thrown to the wayside, in my opinion. I was a very late bloomer with it myself. And then next thing you know, you're middle-aged, and then you're above middle-aged, and you're running out of time. So some of us feel like we're trying to catch up. But I recognize that Social Security retirement was not supposed to be the only income you have. You will be a pauper if for the most part. If you are a high income earner and you're pulling down the nearly $4,000 a month in Social Security retirement, awesome. But those are the folks that probably also had the big Ks and were making so much money to actually have gotten that highest thing because they were making the higher income in society. So it is all kind of relative. The more you have coming in every month your whole life, the more likely you're able to put it into a finer house. That's an asset, a legacy, whatever, can be sold later to go live in a smaller cottage and live a little more luxuriously, all that stuff, and all the ability to save some versus using it for everyday paycheck to paycheck stuff like most of us do. It's tough, but Social Security retirement was not designed for that. They never said it was. So I love the VA PNT because at least many veterans, not all, have that better retirement, sometimes more than they actually lived on most of the years that they're not disabled. So I appreciate that. So I'm glad. I would like to donate some of my back pay to allow you to have Daryl, you already did. You already did. That $50 was super, super generous. You use that back pay for your future. Okay? Because it is a fixed income. Don't forget it. Can't you invest? Make interest? It's not SSI, right? It's SSD. Think about using I have a financial advisor now. I'm at the bottom level of that, but I can finally do it because they cost money. It's a monthly amount. But what has happened to the money that was in there that I finally got it enough to them to do some piddly things with it? It is growing exponentially because it's investments that you can't get into as a person without one of these companies. I know that's not necessarily fair. I'm just saying that's the way it is. Maybe you could do something like that, right? But use your back pay for something good for you, please. For your future in particular. I mean, fun, yes, but for your future, make your future easier. Like if you have a mortgage, if you have a mortgage, you use it to bring it down perhaps. If you don't have a mortgage, but you'd like to have a home that you don't have, maybe it could be used as a down payment on a home whose carrying costs you can otherwise afford on your SSD. And then eventually that's paid off and you don't have any living expenses. Daryl was saying he was fired because he forgot steps. There you go. I know a lot of people like that. SSR, Christina, that was, I'm sorry, that I was just saying short for Social Security retirement. So when you're on disability, Social Security disability, when you get a full retirement age, which is currently for those of us about our age is about 67 now, and that's the maximum. For some people, it's like still 66 and change because they did it on a progressive basis when they increased it from 65 many years ago. Your SSD, if you get on it, is going to switch to Social Security retirement automatically. Amount stays the same when you become of retirement age. And the nice thing is that Social Security disability amount was your full retirement age. You got to take it years earlier and not have to, gosh, at 62, I got to take early retirement, which is 35% or 30% permanent discount off of what my full retirement would be. SSD is like your full retirement amount taken early, and you never have to take that early retirement discount. You never have to file for early retirement because you're already getting your Social Security in the bigger amount as SSD. And then it converts over to Social Security retirement, which I refer to as SSR in this context. But ironically, and you're right to call it out there, Christina, because an SSR, the other acronym is Social Security ruling. And sometimes I do a video when I see an interesting one. I think that's what I just did with the obesity one that's coming out. I think it was a ruling, and I wanted to go over some of it so people don't forget to take note of their obesity that they might otherwise, no one really wants to talk about it, but it can help your case. So that's another SSR, but Social Security ruling. But in this context, I was talking about Social Security retirement. So thank you for calling that out because I know it gets confusing and I blow through the acronyms sometimes. So anytime you guys have an acronym you want me to do, please do. I should write that down. Because someone asked me to do a video on all the acronyms. And I'm like, get me a list of them and I'll do them. But the person never got me the list. So that's why it'll probably take me longer to get to that. Thank you, Christina. Christina says, don't forget to press the like button. I appreciate. Subscribe is also good, but you're probably most of you are subscribers anyway. You can feel free to share as well. No, I only have SSR now, just over 1,000 a month. Okay, SSR. Valerie has social. Oops, sorry, Valerie. I think I just turned you off. Valerie says she has Social Security retirement now because it flipped, right, Valerie? And it's just over 1,000 a month. All right, so it's not super high. As you can see, it's about what it was when you were collecting disability. That was too much for SSI, but it is too much for SSI because it's dollar for dollar after the first $20 of unearned income, which insurance benefits are unearned income. You bought them, but you're not earning them month to month now. But if you haven't done it already, Valerie, look to see if there's any local, if you want, local benefits. Yes, there are welfare of sorts. It could be SNAP. I don't know what the SNAP limits are for a little food assistance, food stamps, if you will. See if any of that's available. Sometimes there's housing help, utility help, particularly in the winter, if you're in the north. That would be a local benefit. Look to your county websites about, even like your county medical assistance office might have the links for those other forms of help. And it just means that less of that 1,000 might have to be used for food. If you get, say, $100 from SNAP, now that's $100 you don't have to take out of your 1,000, right? And you could save it, maybe build a nest egg. You hopefully have a nice nest egg from that, was it a couple years that you got? And hopefully you can use that for what I was just saying to Daryl, like use it for something that's going to make your future more pleasant, less stressful. Maybe it pays off a mortgage or, maybe your mortgage is paid off, but you have a roof that needs to be fixed. That money doesn't fall from trees either. So just some ideas, guys, and all that stuff. Ivalis, is that your name? Ivalis Reyes or Reyes? I'm not sure how to pronounce, so I apologize if I'm butchering it. I'm just going to call you Ivy for now. Ivy says, hi, if an applicant for SSDI was to be approved before the 5th month waiting period, how much does the attorney would get paid? A percentage of the first check? Or no. The contingent fee agreement produced 0 back benefits. The attorney gets 0 from the contingent fee agreement. Now, what there is a secondary avenue to try to get a fee approval of some amount, and that's the fee petition amount. That means he or she has to itemize all the work done, submitted on the fee petition form, which I believe is the 1560. If you guys need it, I think it's HA 1560, or it could be SSA 1560. I don't recall. It's been a long time. We don't get fee petitions very often that we do here. And then if that's the case, then he will go to you to try to get you to get on a payment plan or otherwise pay him. So it is not an ideal place for an attorney. It's usually, for us, it's usually, unless the person's loaded and they're honorable and they want to pay, a $5,000, we come to some agreement on the amount and say, let's do a fee petition for this amount. And they can pay it. And that's some people that have done that in the past. They definitely want to pay. They don't feel like it's right to not have to. However, it is something that the attorneys often have to eat. And this is when I did a recent video, some of you may have seen, about the people that complain, the few people that occasionally voice opposition to paying a $9,200 fee when their perception is the attorney didn't work enough to do the $9,200. You got to realize that's the nature of the beast with contingent fee agreements. You get to pay nothing for all the work if you don't prevail, or if you prevail and there's no back benefits. So you win your benefits, but the attorney gets, so it's all that whole kind of, a protection on either, So, but for you, Ivy, the contingent fee agreement will not pay him anything. There's nothing about first check that doesn't apply. So he or she will presumably have to do a fee petition, or he or she's going to do what sometimes we do, is just chalk it up to goodwill and say, I'm not doing the fee petition. Don't want to see you with the bill. This is particularly true if I have people with they're not wealthy people to begin with, and they have low disability amount. They're not the $4,000 a month person. I'll just waive the fee and I'll eat it, because I don't want to see somebody have a stress over a bill, even if they're on a payment plan with us. It just would ruin the whole thing for me from a psychological point of view. At least half of my positivity out of this field is that that's what doesn't happen, is billing people. So I prefer, generally speaking, to waive the bill and wish everyone good luck and keep me in your prayers type of thing. And it's all good. So, but every lawyer is different. Most will probably do a fee petition, I'm guessing. And in the earlier days, I probably did too, because you had to. But I feel that I'm a different place now, and I don't necessarily have to do that. Yeah, Brian, P&T helps. I'm so glad you guys have it. Yes, it helps you keep the fight. AF Vet is saying that P&T helps him or her keep the fight for SSDI too. Yeah, because you have the wherewithal. I feel you guys put in the time and the sacrifice. So this is well-deserved, and I'm so glad it's there. And if you know me, you know how much I'm into the vets. It does go out for my other peeps who don't have it. They didn't put in the time, and I get that. It is just such a tough place to be when you don't have something like that, and particularly if you don't have family to fall back on, grown children that help. There's some people are in such a tough place, and one they never expected to be in, because we don't foresee this, because again, they don't teach us this stuff growing up. Our education system has really taken a backseat to common sense, but yeah, it's tough. Christina says, you're so kind. I'm not sure what I did that was kind there, Christina, but thank you. Daryl, AFVs, it's hit the like button. Thank you. Yeah. Yes. Like and share, everybody. Right? You bet. Let's see. Gunler, good to see you. You're late, aren't you? Just kidding. How do the grid rules apply if you're already working under SGA? There's no correlation between grid rules and working under SGA. So you're either found that you meet the grid rules, which is whatever your age is, gun lover. Let's say you're over 55. You've proven that you cannot do medium above work, that any work you could do at best full-time would be light or sedentary. You have proven that you cannot do your past job, whatever that job was. And you prove from your medical evidence that you cannot transfer the skills you learned at that past relevant job to one of those jobs, your RFC, which we know is light or sedentary, because it can't be medium, that you can't do. Those skills you learned cannot be transferred to a light or sedentary job. So the more physical those jobs were, the less likely it is that they can be transferred to light or sedentary work. It has nothing to do if you're working under SGA. That has no bearing. That, whether you're working under SGA, the nature of your work, did it show that you could do more than light or sedentary work? Are you lifting 50 pounds at that part-time job, proving that you could do medium level work? That's a whole different finding. That has nothing to do with the grids, right? It has to do with what your RFC would be. That's why the choice of what job you do while working under SGA is super important. How you do it is super important. And yeah, how you do it in terms of, there's a perfect world where you're looking at optics when you pick that job. Because I love it when people are working part-time while they're fighting disability. So they don't have, I thought that was a dog getting into garbage. I think it was the husband. Okay, not getting into garbage. Okay, I hope that helps, Gun. I understand, but with disability, I don't know what you're saying, Daryl. Let's see. Gun Lover says, how do the grid Okay, I just answered that, right, Gun Lover? Valerie Woodson says, thank you, Stephanie. Yes, had to pay most of it back to family that floated me for those several years before SSDI was approved. I understand, and I think that's a stand-up thing to do, being a woman about it or a man about it, right? You honor your family debts and you make your priorities. Maybe you had other debts, but you made the priority to the people that are the creditors that are going to be in your life going forward. Thankful family was able to do that at the time. It was. And, it's also a point of stress, I think, when we're going through it, when we're borrowing from family, right? Because it is harder in a way than borrowing from a credit card where you don't have to feel guilt or anything. So I'm glad you were able to pay back most. And who knows, maybe you're not making that much. I'm not sure how much you can actually send anybody a month, maybe $5, but they're probably totally satisfied and they're just glad that you're able to perhaps self-sustain now, Or, $1,000 a month if you have a housemate or you live with family. I had family living here up until a couple months ago. Most everybody here knows. And she had Social Security retirement. And she, since is my mom, went to live with my sister, who I think can do better care for her now that she's getting older and a little bit more need than I can give. And my sister's a nurse. And yeah, the person who has Social Security coming in, if they live with family, can live way better than if they're trying to live in an apartment and have rides. And if they can't drive anymore, now they're Ubering it. And how do you get to the grocery store? Oh, you can't. So now you got to pay delivery, whatever the case may be. You can live a lot nicer living with family. While you're contributing, but you can have a much nicer digs and nicer quality of life because you're not necessarily having to come up with $3,000 to pay for an apartment, for car insurance, for a car payments, the food, the extra, the utilities, the heat bill. I mean, I look at our heat bill in the winter, we're talking $1,000 a month right there, right? Electric in the summer, because everyone jams their air conditioning. We try to keep it at a decent temperature. That's still like $500 in the summer. So, it's definitely better to share that shelter. And then the person on Social Security can live much better, can contribute to the overall environment they're in, which is not bad for the people that are sharing their space either. It's kind of like it's what family does, I guess. I'm all for it. Brian says it's pronounced Kivil. Kivil? Okay. Kivil. Like, oops, I was going to use a different word. Nope, I'm going to screw it up. So we'll leave it at that. Thanks. Christina says, don't forget to share, comment, and subscribe to the channel. Yay. AF Vet says, do you do TikTok lives? No, I do not. I don't even have a TikTok account. Yeah, Brian, I bet you people screwed up. Yeah, it's one of those ones that can be pronounced differently. Cavell. Because isn't there Cavell? Isn't there a famous actor? What's his name? He does so many good movies. Some good sound. Good. Whoopsie, sorry, dog. Just some good heartfelt movies. Cavell. Is his name Cavell with a C? Do you know what I'm talking about? I forget his first name. He might be one of the. Hey, don't be growling in here. Okay. Ivalise Reyes says, thanks so much for answering in details. You're welcome. I hope I got your details. I have to refresh, but we do the best we can here, given that's posts, right? Well, AF Vet, this is incorrect. Grid rules don't really help if you're a skilled worker, do they? Yeah, they do, for sure. It is not as easy. It's harder to meet the rules, but we do them all the time. A lot of times, because you're thinking about the skilled work, that those skills are going to be able to be transferred. If the skilled work was sedentary, it's the hardest, right? Because they're going to say, well, we do mark you down to sedentary, and we do agree you can't do that other job that you did do, even though it was sedentary and skilled, because you can't do high skilled work anymore. Sometimes because of mental stress, anxiety, diagnosed anxiety or depression. But a lot of times those very mental health struggles that prevent the prior job, it could be that you just can't handle people and have panic attacks, but you didn't forget the things you knew. But the ability to transfer those skills is then impaired to apply it to a whole different industry, a sit down job in usually a different industry. So it can be done. You really have to, I would say generally, if you have no anxiety or depression over your current quality of life changes, it's going to be harder to prove that you can't transfer those skills. And it will depend also on age, like a 60-year-old, even over 55. But there is a definite rule that says something about 60. It's not actually in the grids, but it's this other rule that starting a different job, they say when we're that age, it has to be so spot on the same. Those procedures better be the same. The industry better be the same. The step-by-steps must be the same. Like they're saying it has to be so exactly the same to expect the person that's 60 or above to go into that job, that it can be itself. I use that rule all the time to support and be a backup to that grid rule. I will usually, it is unusual that someone kind of like my age that is disabled and has pain issues doesn't normally, pain itself can be a distraction. It can prevent us from being able to take those skills we learn and twist them around and apply them to a new position that's now sedentary. So we may not think about the concentration that we lack due to pain or the anxiety that builds up as being mental conditions, but they really are. I encourage people to look at them in that way so that they can use the fact that they have them as something that's a medical impairment that prevents the transfer of those skills. It's a little bit of needle threading, but it can be done. But it usually does require that you start addressing medically those things. Okay, Dimple says, and we are now at 2 hours and 15 minutes, guys, so I'm going to try to wheeze through these. Wheeze? Didn't mean that. Whiz? Maybe? Whiz through them? Dimple says, I'm really hoping to win on initial, but also want you to be compensated if you have an opening when I finally apply. Yeah, no worries. We'll have to take a look at that when the time comes. And you know what? You might want to just try. You might want to try it on your own. You know me, I'm always saying everybody should have someone when they start. It's true. But maybe if you're thinking of just banging it out the gate, maybe not. I don't know. That's up to you. And we could talk about it. I know we've touched on it, Dimple. Gun Lover says, payment centers take forever to do. Tell me about it. Reinstatement was approved for the first month. They had to cut me a critical paycheck at the second month. It came in as it should this month. Yeah. Yep. They sometimes take a while. I'm hoping they get back on track. It's been a while. And again, they had to cut a critical pay because payment center still has me processing reinstatement. They made sure to make it continuous as well. All right, so somehow they had some way to do a critical payment flow while they're doing the official getting the reinstatement back on. Is that what it is? Dimple says, PT appointment just completed. I'm very tired. Hope that last comment made sense. It did. I get what you're saying, Dimple. Feel better, rest up. PT is exhausting. Oh, yeah, Christina. Jim Cavell. Yeah, it might be like Cavell or ELLE. He was he has a Christian movie out, and he has other things in the past. I mean, he used to do other stuff way back when, and now he's just kind of getting to the world needs this stuff. He's not really into the Hollywood silliness, I guess, and he's like, thinks the other things are more important. Yeah. He might have been involved in that movie, Sound of Freedom. I took my kids to the theater to see it because I really wanted them to get a gist about human trafficking. Yep, I did. That was me taking the teenagers. It was kind of like come to this movie and then I'll buy you popcorn and maybe we'll go out for pizza. And they did. And I know it was disturbing to them, but I think they needed it. I think it was really good. It's not so disturbing that they shouldn't see it, but they're nearly adults. Well, one of them is an adult now, and they need to understand that it's not unicorn land out there. Passion of the Christ was the movie. Okay, I don't even think I saw that. He's involved with a lot of stuff. I think he may not be on Angel Studios. All right, Valerie says, I do have a home. This is Valerie Woodson, not McKenna. I do have a home with all those bills you mentioned. Hopefully something will bridge the gap. God provides. Yes, my home means a lot to me. It's been a refuge, my therapy of peace through all this. Do you live by yourself, Valerie? Is there a way you can have someone else in paying a appropriate level of rent and utility? Anything will help, right? I know that's hard to bring someone in the house. And it can be hard even with family if you're not going to, there could be strife and stuff. So I tread cautiously when I say that, but how else do you do it? Not $1,000 a month. I don't know. Mind Hack 101. I want to get a job. I hate Social Security. I get it. Are you collecting Social Security now? Or are you fighting for it and it's driving you nuts? Either way, there are videos on how to work under SGA part-time, at least if you want to keep your case going, Mind Hack. And of course, if you can find a job you can do full-time, it might be a special job that doesn't exist in substantial numbers, but you find it and you can do it. And then you don't even have to deal with Social Security, right? Maybe you'll have to later. That's a bridge to cross later. But either way, I get what you're saying. And most of the people I know, my clients, if not all of them, they've been working their whole lives. And this is not where they plan on being. And they would much rather be working. I might have seen one or two that are like, I can't work now, but you know what? I hated my job anyway. You do have that. Not everyone loved their job, but they loved being self-sufficient. And it's a big self-esteem thing, and it's a hard adjustment to not be there and then have to file for the insurance that you worked and you paid for sure. But, because that comes with other, interference with quality of life. So it's not just like, wow, I'm on disability and everything else is the same. That's not generally how it is, right? Yeah, it is a change. I mean, it's even a change for people that don't get disabled, but they eventually retire from their jobs. We've always heard the stories about, retirement not always being the best thing for somebody, because now they're just sitting around eating bonbons. They may not have $1 million to go traveling around the world, and now they don't have a focus. And sometimes it makes a shorter lifespan, apparently. I don't know. It's just all the anecdotal stuff and maybe some studies we've read over the years, right? But it is fascinating. It's like the human spirit, I think. And the best thing for the human spirit is self-sufficiency and not being reliant on somebody else, and certainly not necessarily being, not able to care for oneself, But with your Social Security, once you get it, you are using what you paid for, at least. And it's not welfare. So if that's any consolation, mind hack, they barely pay enough. Because it wasn't designed for that. I don't know if you were here before when I was saying Social Security was not designed to, it was retirement to help us in retirement, add on to the savings we made to prepare for the rainy day of retirement. And somehow we got away from that, whether it's because our standard of living and cost is so high that nobody can save like we were supposed to and did 50, 60, 70 years ago, combined with the fact that our education system has not told us that we are going to need to. It's just imaginary, not even in the sphere to think about. And I think that's really been a big part of this problem, is we don't even teach kids how to balance checkbooks, because again, most people don't have checkbooks, but you still got to balance your registry on your online banking. You can't just write 10 checks because it says you have $1,000 in there, and they don't siphon out fast enough, and you could go use that card multiple times and then you're bouncing stuff. They don't teach that stuff either anymore. And I think it's a real shame. We've gotten away from the basics, to teach underwater basket weaving because it's cultural, I suppose. I just think it's ridiculous. If Vet says, I'm 54.3, okay, and have mental health, anxiety, depression, and PTSD. Hopefully this helps me in my ALJ that I just had. I did have neurophysical exam that showed memory issues, learning, and significant executive function deficiency. Okay, it may or may not. To have a grid, remember, you have to have physical too. So at 54, you're younger than me, but usually way by the time we're 50, we start having our body parts are not as young, strong, active, or pain-free as they were when we were 20. And I always say, focus on those parts that are not and start getting them worked up with a specialist and find out if you have mild arthritis in that. Mild arthritis might be all you need to show that you can't do that heavy job you used to do. And that might be all you have to do, because remember, if you're gritting, you can't do that prior job. Now you got one out of the 3 rules covered for you. So, and then you have to, we've got over the 3 rules, but 3 rules before. I probably have a video on your age group out there. Look under grids, maybe, if you want to look at the playlist. If not, I can do another one. Just let me know. Valerie Woodson is saying she thinks it's Jim Caviezel. I don't know. I'll have to look it up. I'm going to look it up because now I'm curious. Valerie Woodson said she might try a roommate to help cover the expenses of what her Social Security might not cover. And it's hard. How do you, if it's a stranger versus, I know, if you come up with good tips for people, if you do it successfully, Valerie, maybe you should do a blog on it or a podcast or something, because we all think about that if we ever have to do that. I think many of us do anyway. And it's scary. You want a well-vetted person. You want someone you can rely on and trust and have enough space where you don't get on each other's nerves too much. Are they a slob? Is there going to be house rules about keeping things neat? All those things. Daryl says, have a good weekend. Stephanie, hope all's going good with your husband. Yes, he's doing great. Thanks. He's home. He's puttering around out there, probably getting something to eat. Thanks, Daryl. And thank you for the generous donation. That was really super sweet. Valerie says she loved her career as an occupational therapy assistant. It was so rewarding. Oh, I bet it was. I thought I'd be working not on SSDI and now a reduced SSR. No, you're not reduced, Valerie, unless you did take early. Oh, did you take early retirement, Valerie, when you were waiting while you were borrowing from family and taking early retirement to cover those bills while you were fighting the claim? Is that why you had a reduced Social Security retirement? Because those early retirement months, if you took them and they were not part of the ones that flipped over to SSD, even though it's been a couple years, your 5 years, there was a couple years that you were 62 to 64 before you applied for SSD or the SSD months kicked in. Yeah. Yeah, that is tough there, Valerie. If you did do that, that's where it's good that you filed for SSD because you did flip 2.5 years worth of that early retirement to SSD. So those reductions will no longer apply, but you might still have, what is it, 2 years that you were taking early retirement at 62 to say 64, and then the remaining 3 got flipped over, or maybe 3 years of early retirement that can't get flipped over because you didn't apply or weren't disabled. I don't know what your details are, but I get it. Yeah, it's tough. You're welcome, Valerie. Okay, AF Vet is adding that not just the mental health problems, but severe, I think you're saying facet arthritis, FACET, in several lower back, probably several levels of the lower back, and chronic dizziness, PPPD. Okay. Yeah, keep those worked up really, really well. Focus on those, because I'm sure you're already focusing on the mental health, so those records are going to be there. Lower back, orthopedist, physical therapies. They'll give notes about the pain that it causes you, that you complain about while you're there. Updated MRI and probably x-rays for the arthritis. I want to make sure I have those. I know I think you had your ALJ hearing, so fingers crossed that was all done, or he otherwise can find it. Maybe the chronic dizziness is well established. That would take you out of medium work for sure. May or may not take you out of light. Could, because light means you're on your feet a lot, and if you're dizzy on your feet, that could be a problem. Won't necessarily take you out of sedentary work, but you're how old did you say you were? 54. All right, you're still at the age where you have to prove that you can only do sedentary work. Chronic dizziness might allow for sedentary work. Might. Painful lower back might negate the ability to sit for 6 to 8 hours, which is sedentary work. So depending on how you thread the needles, build that evidence and those details and present it, that needle could be threaded or it might not. You might have to file again. You might not. Fingers crossed that you get it on at 54. If not, you try again. And then again, 55, you have a slightly easier threshold. You still have to prove them though. So anyway, yeah, definitely. I think you said you sent in a thing. I'll take a look. It sounds like you might be in the category though. Where am I at? Ah, look at Christina looked it up. Here we go, guys. Jim Caviezel. Oh yeah. So was it Valerie that made a guesswork on the spelling? You did a good job, because I was saying Cavell. I was wrong. Yeah, he's really good. All right. Yeah. So Valerie took early retirement. We talk about this sometimes, guys. She took early retirement at 62 because she could not work, and she then filed for Social Security disability. And for some of those early retirement years, she was able to prove that she was disabled. So they're going to flip those. But those earliest part of the early retirement, she did not have a case for SSD and did not prove that those years were disabled also. And that's why some of her primary insurance amount is reduced for those from the Social Security retirement amount, which is also the SSD amount. So she reversed some of the damage done by early retirement, but couldn't reduce all of it. Couldn't eliminate all of it or reverse all of it. Daryl, you're very welcome. And thank you again. Daryl is saying too that from the VA, and for the benefit of AF Vet, you can get an alarm device and a walker from the VA if needed, right? Yeah. Again, Valerie's emphasizing that she took early Social Security due to COVID. I guess maybe you lost your job, so you had to and couldn't find other work. COVID reduced work hours by 2/3, then got severely ill and subsequently filed SSD 7 years later. Yeah, I'm sorry. That blows, but I'm glad you won now. And hopefully, you are able to work part-time if you can, whether it's privately, self-employed. You don't even have all those things you have to keep an eye on. Maybe you can get a accommodated job through like a senior disabled working network, vocational rehab. Worth looking into if it's something you want to be out and about doing and making a little extra coin. If nothing else, you can build a savings again. Something to think about. Worked in nursing homes. Valerie, my mom moved out. We moved her to Minnesota. I took her to the Indiana. My sister came, picked her up the rest of the way. That was a few months ago. It's definitely different here. She's been here since my kids were 3 and 4, but she needed more. And my sister is an RN and has years of experience in nursing home work. So I thought that's kind of perfect. And she was game on. She was stand-up daughter. I was really glad. My mom had been with us for 14 years when she couldn't work anymore and needed a little help. Now she's 82. And my mom was a nurse, and my sister's a nurse. My sister's kind of semi-retired. You're saying your disability is very limiting. So maybe that part-time work is out of the question. Sometimes people do house sitting for a little extra coin. I don't know. Everyone varies. Some people can, some people can't. AF Vet says, I have a new MRI showing damage to back. Good. Go to pain clinic, MPT. Okay, very good. You got the physical stuff. That is what I was driving out, AF. I know you were focused on the mental health, but I'm glad to see. Not glad that you have physical problems, but glad to see you're addressing them for your case purposes. Regularly for both back and dizziness. I want to get better. I'm in Minnesota and love it. Oh, okay. I think you just heard me say my mom's in Minnesota, my sister. Yeah, very cool. All right. I think we're wrapping it up, guys, right? We're at 2.5 hours. You all are fortunate with help from family also. Yeah. Yeah, my mom, I mean, I'm so grateful that, you know, she had us and she also has my sister, who's the one with the skills that I lack. And I really felt like her needs were becoming where I couldn't do them well and what she needed, including getting her out and about in the community as much as she should use. My work is really busy, as you can imagine. So, I mean, I'm fortunate that I run the show myself, so I could take, you know, 3 hours off in the middle of a day and take her to a fun place, you know, like she likes to shop, and I could make it up later, but it didn't happen as much as I wanted it to. And she stopped driving during COVID, and I thought that was good because I thought it was unsafe. It was becoming unsafe. So that was kind of when I went, and we're not going back to the driving mom, you know. And I actually switched cars, so she'd have to drive a truck. So I don't think she was keen on it. But yeah, she'd get lost and stuff now. Anyhow, all right. Thank you, guys. I appreciate y'all coming out. I know this is our off day. It's Friday. We don't normally do it on a Friday. It's usually Wednesday, and it will be Wednesday again. I appreciate you guys pulling through and coming on Friday so I could change the date. I appreciate it. I did have to make sure my dear husband was discharged and able to get out because he was getting stir crazy. So that's what that was about. Originally we thought he was going to be out Tuesday, and so my Wednesday was going to be fine, but he had to stay an extra day to a minor, I wouldn't even say it was a complication. It was more of a precaution. And so all so far good with that. So anyway, thanks, guys. I appreciate it. Wednesdays at 12 o'clock daily is a video share of some kind or other, Social Security related. And Wednesdays, 1 p.m. Eastern Standard Time is our live stream for all things Social Security. So you can come ask your questions and say hello, if nothing else. Thanks, guys. I appreciate it. Bye-bye.